All right. All right. Well, that was the result of me hitting the wrong button. Didn't mean for that intro to go off quite that quick. But nevertheless, here we are. Welcome, everybody, to an impromptu Law of Self-Defense show. I don't know if anyone's going to get a notification of this quickly enough to jump on board. But that's okay. The show serves a couple purposes. One, of course, is to share self-defense law expertise with all of you. Another is to do a little bit of a technology test. We've done some reconfiguration in my office here, added another monitor, moved some lights and microphone stuff around, moved our soundboard around, and we do have a webinar we're doing tomorrow. Hey, guys, come on in. We do have a webinar we're doing tomorrow, so I just, frankly, in complete disclosure, this is a bit of a technology assessment as well. Make sure we didn't pull out any important plugs in reconfiguring my office. But I do promise to do more than technology assessment. We'll do some real self-defense law as well. I presume the audio is okay, or somebody would have told me. Folks, if you have not yet, if you could hit that subscribe button. If it's orange, please turn it gray. Smash it. Hit the bell to make sure you get notifications, or at least have some prospect. Hey, good to see people coming in. Sorry I did this at such short notice. No notice, really. And if you could hit that like, thumbs up, and drop a comment in the chat, that's appreciated. Even if the comment's just your city and state, it helps fool the YouTube algorithm into sharing the content more widely. So my plan for today's show, in addition to, let's see, making sure the cameras, everything are working correctly, is mostly just to answer self-defense law questions. Now, as many of you may know, one of the levels of membership we have here at Law of Self-Defense is our Platinum Protection Program. And those are the folks, the only folks on the face of the earth who are eligible for my self-defense law legal consult if they're involved in a use of force event. But I'm not here to push the Platinum program tonight. But one benefit of the Platinum program is those members get a dedicated online form to submit questions directly to me, and I promise to answer their questions. And we have a bunch of those piled up that I'm going to share with all of you. Now, the Platinum members, when they submit their questions to me, they can also submit them in confidence. And when they request confidence, and obviously we don't share those questions or answers more broadly, that's part of being a Platinum member. But most Platinum members, when they submit their questions, don't mind if we obviously, in an anonymous fashion, share the question and the answer. And that's what we'll do on today's show. Now, as we're going through this, if it turns out you have your own self-defense law questions that you would like to pose, we can certainly address those as well. Just put them in super chat form, and I would be happy to address this. And because I did do this in such impromptu fashion, I forgot to put anything on our Twitter about it. So give me just 1 second to knock this out, and hopefully bring more of the self-defense law self-defense community into today's impromptu show. There we go. Let's see. Not sure if Instagram, did Instagram go? I'm going to hit Instagram again. I think I might have forgotten to post that up there too, because I know all of you thinking, Boomer, you would be exactly correct. And there we go. All right. Turn back here. Turn back to the chat. When you lived in Boston, someone asks me already in the chat, when you lived in Boston, did you hate when Boston won all those sports championships? Post 2001, man, we won a lot of them. It was a crazy period. It seems like every sports team was winning like crazy, particularly the Boston Red Sox and, of course, the Patriots. There was a lot of wasted time in the office with people talking ball sports instead of work. I'm a pretty bad sports sports fan. I really only watch sports when the local team is winning like crazy, which ironically enough meant I watched quite a bit of sports in Boston during that era. No, I didn't mind the victories. It didn't bother me. It was fine. And I have to say, I loved living in Boston. I mean, you have to put the politics and the gun laws aside, but in terms of a physical location to live, the city of Boston was great. Really, really nice. Okay, so let me pull up this. Let me pull up that. Let me pull up this other thing just to make sure everything is working as it should be. Here's Rumble. Looks like Rumble is working okay. Let me pull up our Law of Self-Defense membership page. Make sure those folks are getting the access they're supposed to be getting as members. And by the way, if you have questions you'd like answered and you're a Law of Self-Defense member, don't bother doing a super chat. Just put it in the membership, in the chat of the membership stream. And obviously, your questions always get answered. And it looks like that is working as well. All right, awesome. So, anything I need to dive into before we get to the questions? I don't think so, except Viva Barnes is pinging my phone. Except, of course, I should mention, because it's much, much less than 24 hours away now, is tomorrow's Saturday. For those of you who might be watching replay, I'm talking about Saturday, April 16th at 2 p.m. Eastern Time. We have our Law of Self-Defense Hard to Convict webinar. These webinars are 100% free, but there are limited seats. So we only have seats for 100 people. I'm not even sure there's seats left for tomorrow. I don't think there are, but you can give it a shot at lawofselfdefense.com/hard to convict. Grab a seat. If you see the date listed there, there's still at least a few seats available. And you can grab your seat there. Again, they're 100% free. What we do in these webinars is they're a little under 2 hours in length, and we do a bunch of self-defense law myth busting, the kinds of myths that are common in my experience for gun owners to believe because, well, they've been taught this. Their concealed carry course told them, or the gun magazines or gun forums told them, or they saw it on the internet someplace. Bad self-defense law information. The issue I see most people running into in cases I consult is not that people didn't know self-defense law. They knew a lot of self-defense law. It's just what they knew was garbage. And unfortunately, they followed that garbage, and that gets them and potentially you into legal jeopardy. So if you'd like to have those myths busted, tomorrow's webinar would be the place to do that at lawofselfdefense.com/hard to convict. And we will also be sharing with all of you a path of transformation, a way to ensure that should you be compelled to use force in defense of yourself or your family, which in an increasingly violent country, unfortunately, is increasingly likely to be the case, that you effectively defend yourself and your family decisively, but you're hard to convict in the process, not easy to convict. I don't want any of you to be easy to convict, but the only way to be hard to convict is to know where the legal boundaries actually are. Frankly, based on my experience teaching hundreds and hundreds of full-day live classes on self-defense law, the chances are probably most of you are in a position where you are easy to convict. It's not because you're bad people, it's because you were mistaught. No reason for that. No reason to be easy to convict. If you'd like to transform yourself from easy to convict to hard to convict, then our Law of Self-Defense Hard to Convict webinar is a huge step in the right direction for that. Anyone who's been in the seminar before, we have several of these scheduled for, this might be the last one for this month, but this month and next month. And we've done a couple already, so maybe some people in the comments would have seen it. Can feel free to comment and let folks know how you enjoyed it. All right, so let's see. The lighting is not quite right. Not too bad. We'll see. The tie's okay. I am wearing pants, folks. It's not just a tie. Okay. So I'm going to start with questions that were posted up in our Platinum members Q&A forum, obviously in an anonymous fashion. And as I ask those, if anybody in the live audience has their own questions or prompts a question, I'll be happy to answer your question too. You just have to put it in super chat form if you are come on, if you're watching on YouTube live while this is taking place. It's taking place live on Friday, April 15th in the evening. Or if you're a Law Self-Defense member, then just please put it in the chat. Hey, Doug's in the Law Self-Defense chat. Oh, Doug T says in his chat, he just signed up for TACCON, that's Tactical Conference 2023. The registration for that just opened a couple of days ago. I just taught at Tactical Conference, TACCON 2022 last month, as always, and I taught the year before, and I've taught many times there in the past. Always a great experience. Folks, if you have any interest in having a well-diversified skill set in self-defense, guns, bare hands, medical, tactical, different kinds of guns, shotguns, pistols, all kinds of instruction takes place at the Tactical Conference, including, of course, legal stuff. Masad Ayub taught there this year, as he did last year, and probably most years, maybe every year. Of course, I teach there. There, I know few places where you can get as rounded an education in a 3-day period at as reasonable a cost as at the Tactical Conference hosted by Tom Givens and Lynn Givens. The last couple of years in Dallas, and again in Dallas next year for Tactical Conference 2023. They generally take place around the last week of March. But I heard from an insider at the Tactical Conference that registration opened just a couple days ago, and within 2 days of registration, it was 40% full already. So if you're thinking of waiting until January or February to sign up for TACCON 2023, forget it. I mean, it'll be long sold out by then. And yes, I am teaching there again in 2023. I will have, so in the past, I've taught 2 basic courses, basically the same basic course twice over the 3-day period, which is fine. I don't mind doing that. But I believe next year I'm going to change it up. I'll have a first initial basic course like I've always taught, which is basically the 5 elements of self-defense: innocence, eminence, proportionality, avoidance, and reasonableness. And then I'd like to do a 2-hour or maybe longer hour course. It depends on how the TACCON folks feel about it. A more advanced course on the application of those elements to real-world use of force cases that have been in the news over the course of the year. So I expect that's what we'll do at Tactical Conference 2023. It's an amazing event. I strongly encourage you to sign up, assuming seats are even still available. I believe their website is TACCON, so that's TACCON.info. But folks, I would not be surprised. I mean, it just happened last month. 2022 was last month. I would be surprised if by the end of April, this month, it wasn't sold out for next year. So if you're all interested, I would encourage you to take a look. Another conference you might consider as well that I'll also be teaching at is the concealedcarry.com Guardian. I believe they call it the Guardian Conference. That's concealedcarry.com. That's Jacob Paulson and Riley Bowman. I do a lot of work with those folks. They do great work. In fact, when our books ship out of the warehouse, they host our warehouse. So they're our warehouse guys. But they do a lot of great work just other than that, of course. And let's see what they call that thing. Guardian Conference 2022. GuardianConference.com. And that takes place in... so the Tactical Conference takes place in Dallas. The Guardian Conference 2022 is this September, the middle of September, in Oklahoma City. Yeah, that's the nearest big city, Oklahoma City. And that's a great conference as well. And I'll be speaking there as well. I don't really do live in-person classes anymore, folks. So if you're interested in seeing me teach live, really the Guardian Conference and the Tactical Conference are the 2 major events where I show up and teach in person. So if that's of interest, that's what you ought to do. Let's see. There was, I did see a super chat pop up. So let me take a look at that so they don't so they don't accumulate. What do we got? Daryl Conger. Wow, $20. Daryl, thank you very much for your super chat contribution. I really appreciate it. Writes again, my favorite YouTube channel and book are extraordinary. Folks, this is the book. If 200 pages, a real physical book, we give the book away for free, folks. In fact, I think I have a little image I can pull up for that as well. Let's see. I didn't, as usual, I perhaps did not prepare as comprehensively as I could have. Let me pull up this image here, click here, click here. Here's our free book offer. So that's for this book. The one well, not this exact book. You'll get a different one from the warehouse, of course, but this actual physical book, it's not just a PDF or ebook, folks, although we have those variations available too. But this is for the physical book, the soft cover, Law of Self-Defense Principles. If you look on Amazon, there's over 1,000 reviews, 5-star rated. It's very, very favorably received, I should say, as well as perceived. And you can get the book for free at lawofselfdefense.com/free book. Now, you could order it from Amazon, and Amazon will charge you for the book. I forgot what it is, maybe 20, 25 bucks for the book, plus shipping and handling. If you order it from us, we eat the cost of the book. We do ask you to cover the cost of shipping and handling, the cost of getting the book to you. But as long as you're willing to do that, we'll eat the cost of the book, and you can get that at lawofselfdefense.com/free book, as indicated up there on the screen. So back to the super chat. The book is extraordinary. Thank you, Daryl. The Michigan police shooting. Do you think it's a solid self-defense case? Also, could the officer have just let him go after the altercation turned violent? Yeah, I wrote about it at the Law of Self-Defense blog. This would be the Grand Rapids shooting. I think I covered it too in maybe yesterday's broadcast. I'm not going to share the video again here because it's the kind of video when I share it, YouTube instantly demonetizes the stream, just the way they are. But I did share the complete video, the complete police department press conference, actually about an hour long. It's kind of an interesting video situation because part of it is caught on body camera, and then the officer's body camera gets disabled in the fight. Part of it's caught on the officer's dash cam. Part of it's caught by a bystander's smartphone. So it's kind of chopped together video of this event. For those who don't know, it was a Grand Rapids police officer made an arrest of Patrick Leoya, something like that, pronounce his name. Of course, the officer was white, and the suspect, who violently resisted, fought the officer, seized control of his taser, and was then shot dead by the officer, was black suspect, black male suspect. So we have the usual crowd. The Benjamin Crumps are crawling all over this case. But I've looked at all the video, and it looks like about as clean a shooting as you could possibly imagine. Once the suspect, already violently resisting arrest over a traffic stop, which suggests, of course, that if a cop pulls you over for a bad plate, wrong plate on the car, which of course he's privileged to pull you over for, he's run your plate and it's not the right plate for the car, it starts as a traffic violation. But when you begin violently trying to flee and then resisting arrest, which would be lawful once you attempt to unlawfully flee from a traffic stop detention, the cop can infer that there's more going on here than just a bad plate, right? You don't have to run away from a bad plate. You could just take the ticket. So anyway, the cop goes to make the arrest, and he tries, because the suspect is violently resisting, the cop goes to his taser, discharges the taser at least once, and the needles don't connect, so it doesn't work, as tasers often don't work. The officer may also have deployed the taser twice. It's kind of hard to tell from the video. And tasers that throw darts, at the most, they have 2 shots. But even after firing both sets of darts, and if he did fire it twice, the second time didn't work either. But even after firing both sets of darts, you can still use the taser in drive stun mode, meaning just press the muzzle of the taser against the suspect or victim and discharge the weapon and shock the suspect that way. Well, the suspect here got control of the officer's taser. The officer had his hands off the taser and the suspect had it, which means the suspect is now in a position to at least drive stun the officer, disable the officer, take the officer's gun, with the debacle that would surely follow that. And it was at that point, when the officer lost control of his taser, that he ordered again to released the taser. The suspect did not. And the officer shot him. We tend to think of tasers as non-deadly force, but it's important to understand, folks, that a taser used in lawful defense or lawful use of force by an officer is non-deadly force. It's not intended to cause death or expected to cause death or serious bodily injury. But a taser used offensively, unlawfully to facilitate a crime, like violently resisting unlawful arrest, that's an offensive use. That is deadly force. That's being used to unlawfully disable someone. Disabling someone is serious bodily injury, just like knocking them unconscious, especially when you're disabling a uniformed cop trying to make your lawful arrest, who obviously has a gun on his person. So no, this is about the Grand Rapids thing was about as clean a shooting as I could imagine. Doesn't mean it's not going to be a circus. We'll have to see how things develop. Doesn't mean that Benjamin Crump is not going to make another $10 million on this case. I mean, politicians love to spend other people's money, taxpayer money, to make their own political problems go away. So sure, this could be another $30 million settlement for no particularly good reason. But in terms of a criminal liability for the officer, I just don't see it here, absent some new evidence that was not clear in the videos. Could the officer have just let him go? Well, yeah, sure. The officer can always just let him go. The officer could not have made the traffic stop, right? I mean, but we don't live in a world where officers are told, hey, if you see a traffic violation, don't make the stop. I mean, if that's the world we're going to live in, what do we need police for? So the world we actually live in says that if we have traffic cops, they can pull people over for a traffic violation. If they pull people over for a traffic violation, that person has to comply with the detention. They can't simply walk away. If they try to walk away, the officer is allowed to detain them. And if they resist detention, the officer can arrest them. If they resist arrest, the officer can use the force required to effect the arrest. Maybe if somehow the suspect got away, I mean, the officer can't just shoot him in the back if he's running away. But if they're in a, nipple rubbing fight, as Nick Rekieta might put it, and they were in this instance, and the suspect gets control of the officer's gun, the taser, the officer is allowed to infer the suspect intends to use the taser in an unlawful, offensive, deadly force manner and use deadly force in self-defense. I mean, the officer could have stayed in bed that morning and not come to work, and this wouldn't have happened. But that's not a reasonable analysis of how we expect police officers to do their job. Okay. So far I've done a big commercial for Tactical Conference and Guardian Conference and answered only one question. So let me go to the platinum questions here. I don't think we have any new super chats yet. Not yet. All right. So question came in from Larry, one of our platinum members. He says, why in trials does the prosecution or defense not make their case by stepping through the 5 elements in a clear way, like a law of self-defense analysis? Rather, we instead see or hear how they get lost on irrelevant tangents or chase an avenue without first or eventually making it clear why. That's a great question, Larry. And when Larry's talking about the 5 elements, he's talking about these 5 elements. These are the building blocks of any claim of self-defense. They are innocence, imminence, proportionality, avoidance, and reasonableness. Anybody can download this 5 elements of self-defense law cheat sheet for free. We don't charge a penny for it, just a PDF download. You can get it at lawofselfdefense.com/elements, lawofselfdefense.com/elements. But this 5 elements of self-defense law apply in all 50 states. Now, sometimes, often, one or more of those elements may be waived and therefore not required. But it's the most that would be required are those 5 elements. And the elements that are required in a self-defense claim are each targets for a prosecutor. So a prosecutor doesn't have to disprove your claim of self-defense entirely. He only has to disprove any one required element of innocence, imminence, proportionality, avoidance, or reasonableness. If he can do that, if he can disprove any single element beyond a reasonable doubt, then your claim of self-defense collapses. You don't have a self-defense justification. So, and a prosecutor knows that, of course. When he goes into a self-defense case, he knows what his job is. It's not to prove you're the guy who fired the shot. You've already conceded that by claiming self-defense. Self-defense is a defense of confession and avoidance. You confess to the underlying criminal conduct. and you attempt to avoid criminal liability on the grounds of justification. You're not saying it wasn't me, I have an alibi. You're saying the opposite of that. You're saying it was me, I shot that guy, but I did it with the legal justification of self-defense. So if the prosecution disproves self-defense, it's kind of a walk-away conviction, right? Because you've already conceded to the shooting itself. So given, and by the way, that 5 elements structure applies in all 50 states, applies in the District of Columbia, Puerto Rico, Guam, everywhere that American law applies. Now, every jurisdiction will have its own statutes and jury instructions and case law, appellate court decisions, but they all follow this 5 elements framework because this is very old law, folks. This law dates back to the ancient Greeks and Romans. We got it from Old English common law hundreds of years ago. And it's just because it's such old, well-established law, it's highly consistent across the 50 states. There's variance in the details, and of course, details matter. They can mean the difference between an acquittal and a conviction, but the general framework of these 5 elements applies no matter what state you're in. So if it's that straightforward, why don't prosecutors or defense lawyers explain their narrative of guilt, why it's not self-defense by the prosecutor, or not guilt, why it is self-defense by the defense? Why don't they use this 5 elements framework? Well, sometimes they do if they've been exposed to what we teach at Law of Self-Defense. Now, we're accredited to teach continuing legal education to lawyers in 35 or 40 states. I forget the number. We've never been denied accreditation. We just haven't gone to all 50 states to teach CLE. And when we teach it, we're invariably told it's the best CLE those lawyers have ever taken. And those lawyers are familiar with this 5 elements framework. And of course, what they need to do is take the 5 elements framework and apply it to the specific statutory language case law of their state, which is not hard to do. Once you know the 5 elements, you'll find the language in the relevant statutes that are the 5 elements in each state. The trouble is most lawyers have not taken our educational offerings or read our book. And we're not taught this stuff in law school as lawyers. We're not taught this stuff professionally. And to my knowledge, I'm the only CLE instructor in the country who does this. So if they haven't been exposed to law of self-defense, they don't know the 5 elements. And if they don't know them, they're not going to build their legal narrative around it. What they end up doing is building their legal narrative just around kind of the statutory language that applies, which tends to be rather opaque to jurors. I mean, legal language is legalese to most jurors, so it's just not the most effective way of doing it. But there are lawyers who definitely are exposed to our teaching who do apply the 5 elements. When prosecutors and defense attorneys don't, it's because they're ignorant of that 5 element framework. And I always feel like I have to put that in context. When I say ignorance, I don't mean they're stupid or something's wrong with them or they're defective. I mean ignorance not in a derogatory sense, but in a technical sense. They literally just don't know. They don't possess this knowledge of the 5 elements framework. That's why it's not applied in their cases, which is too bad. Unfortunate, because the cases would go better. It's always better to have a clearer narrative to sell the jury. All right, Larry, hopefully that answers that question for you. Let's see, we got the next one here. I actually haven't looked at these questions, so I'm seeing them for the first time, just like all of you. So it's possible I may have to skip one or two. Oh, another question from the same Larry. Let's see. Larry asks, why may not expert witnesses testify why or how a certain action was indeed legal or the correct thing to do? It is said a jury is the finder of fact, but the jury needs to be educated by one or more experts. What else is the purpose of the expert witness? So it's kind of a fine point, Larry. There was a time 20, 30 years ago when it was fairly common for use of force experts that I knew personally, so pretty prominent people in the legal industry, for use of force experts to come into a trial and testify that, in effect, the defendant's use of force in this instance was reasonable, period. Or alternatively was not reasonable, period. But they were permitted to state an opinion on the ultimate fact question. Reasonableness, of course, is one of the elements of any claim of self-defense, really kind of an umbrella element that sits over all the others. Um, so it's a key issue in any self-defense case. Was the use of force reasonable under the circumstances? And it wasn't uncommon 20, 30 years ago for use of force expert witnesses to be allowed to state an opinion on reasonableness, period. That's generally not permitted anymore. It's fallen out of fashion, and frankly, for good reason. Because if there's a ultimate question of fact, the jury is supposed to decide that. They are the finders of fact. It's not supposed to be an expert witness. Now, it becomes a fine point because what an expert witness can do and really should do is provide the jury with all the steps to get to a conclusion of reasonableness without putting the period on the end of the sentence that it was or was not definitively reasonable. So the expert can talk about things like the tool or drill or the threat of a blade or disparity of force or the stress of being under attack or how stress affects vision or memory or recollection or reaction times or all kinds of things from which a jury might build a conclusion, building blocks from which a jury might come to a conclusion that the use of defensive force was reasonable. The expert can provide all those building blocks. What he can't do is stack them for the jury and make it into a house of reasonableness. He just can't take that last step. And it's hard for me to argue against that. Now, I do see, especially some old school expert use of force expert witnesses who used to be able to do it the old way, and the judges didn't seem to mind appearing astonished that they're not allowed to do that anymore, come to that ultimate conclusion of fact. But generally, they're not. Most courts will not allow that anymore. So you have to presume that's not going to be permitted. Okay, so that was another question. Let me take a look here at the super chats again. Refresh. And we do have another one. Let me take a look. Kevin Dorr, thank you for your super chat contribution. He asks, if your really hot, crazy wife did a number 2 on your bed because she's mad you showed up for her birthday party late. Oh, was that the reason? Could you or your bodyguard shoot her while she's in the act and claim self-defense? The answer, of course, is no. I presume Kevin's referring to the Johnny Depp, Amber Heard civil trial that's occurring now. Johnny Depp married to a pretty young thing, half his age, apparently a rather toxic relationship. She kind of implicitly claimed that she was the victim of domestic abuse at his hands, effectively destroying his career, according to him. So he's suing her for $50 million for defamation, and she's countersuing for $100 million because his lawyer supposedly defamed her. It's a little complicated. But one of the alleged acts in their relationship was she took a literal dump in the marital bed, which, well, seems like an overreaction to almost anything. But of course, it does not represent an imminent threat of death or serious bodily injury to Johnny Depp or his bodyguards or anybody else, except, I guess, the bed. So maybe the bed could defend itself, but the human beings, no. Her pooping on the bed does not justify a use of defensive force. All right, back to the platinum questions. Let's see what's next. Another one from the same Larry. Larry's busy in the platinum member Q&A form. All right, he asks, if a fair and impartial jury is not possible, for example, there's an inevitable lynch mob or near certain known results at the hands of woke lemmings who follow fake news even before the trial, so the defendant's a lamb going to slaughter, and the judge will proceed to trial anyway. What is the defender's legal recourse? Undesirable plea or inevitable conviction? Well, Larry, both of those are options. And there's other options, of course. I mean, if you get an inevitable conviction, presumably your lawyer will have seen an unfair, not impartial trial coming at the client, at you, and would have filed motions for a change of venue or various changes to how the jury selection process is used, maybe more strikes. There's a variety of strategies he might pursue. More vigorous questioning, pre-voir dire questionnaires that might expose bias on the part of prospective jurors, trying to get mobs kept a certain distance from the courthouse, things of that sort. There's a variety of steps a trial might take, and sometimes they do and sometimes they don't. And sometimes it's pretty obvious, at least to me, when I'm watching jury selection in some of these cases, that people are in fact lying their way onto the jury to convict this defendant, regardless of the facts or the law in the case. Now, when your lawyer asks for all those things, anything the judge denies would be objected to, and that preserves it for an appeal. Like I say, appeals are for losers. Both technically, if you're appealing, it's because you lost a trial. Also, it takes years typically for appeals to have any effect. And meanwhile, you're spending all that time in prison. And when you win an appeal, it's not like they find you not guilty. They simply give you another bite at the apple. You go through the whole trial process again, and frankly, you may not have any money for a second trial. That's extremely common. You spent all your money for the first trial, as a normal, reasonable person would do, in an effort not to spend the rest of their life in a cage. So it's just unfortunate. I mean, we live in an era where these trials are allowed to go forward under these conditions. And my position, my legal and political, philosophical position, is that the answer to circumstances in which a defendant cannot be given a genuine, fair, and impartial trial is not to give him as an imperfect, an inherently defective trial. Just do the best we can, knowing we're giving that defendant a defective trial. My solution would be, if the state cannot provide a fair and impartial trial, they can't try the guy, period. Because I think we have an absolute right as American citizens to a fair and impartial trial. And if that can't be delivered, the answer is not to deliver a defective trial. The answer is to deliver no trial. You cannot try that defendant until you find a way to actually deliver a fair and impartial trial. Unfortunately, in this area of social media, and where there's been a year or longer between the event and the trial, a year or longer of propaganda, brainwashing the populace throughout an entire state or even an entire nation or the whole world, it can be difficult to put together a fair and impartial trial after that kind of propaganda campaign. In which case, my answer would still be, you can't try the person, because you ought not try someone unless you can deliver that fair and impartial trial to which we are all privileged as American citizens. Okay, let's see. Next question. And this one, I know this guy won't begrudge me saying his name. This is Will Parker. Will Parker is a good friend of mine, personal friend. Also a graduate of the Law Self-Defense Instructor Program. Will's a great firearms and self-defense instructor up in the great state of Montana, up by Glacier National Park area, Kalispell, that part of the state. It's almost Canada, but not quite. Beautiful country up there. Will's a great guy, great instructor. Still have to get my motorcycle up there to do some riding with. Do some motorcycle riding up in that beautiful part of the country. I think Will's going to Alaska this year, if I recall correctly. He tried to get me to go with him, but I couldn't swing it. Too many other obligations. All right, so Will says the context for all this is the responsible concealed carrier. He asks, would you please address John and Jane Public being quote unquote trained, meaning only taught how to shoot and nothing of any further substance, taught this stuff by police, military, Navy SEALs, or special forces, and the jeopardy from that limited scope and mentality alone. Additionally, the I don't need training because I was in the military. Most of the public, as well as the police and military, don't understand the difference in context or the jeopardy they are being placed. or placing another. My head hurts from banging against the wall, table, and rocks. Yeah, well, Will, I could not agree with you more. Unfortunately, I always caution people that when it comes to my own area of expertise, self defense law, you can't assume that people know this stuff just because they have a certain job title, just because they're a lawyer or they're a firearms instructor or a concealed carry instructor or an ex police officer or a current police officer. Or ex-military or current military, because I can assure you that most of those people don't know the actual law of self-defense. Well, unfortunately, that also applies to other facets of self-defense, like self-defense tactics, like shooting a gun, like barehanded skills. They have some training, but often it's not comprehensive or deep. It's the minimal that their job required. And especially, when it comes to cops, most police departments don't. You'd be shocked at how little training and how little maintenance is done on that training over an officer's career. Most cops I've seen don't shoot very well. There are notable exceptions. So I'm certainly not saying that all cops are bad shots, by no means. Some police officers are world-class shots for sure. But not most of them, any more than most people who own guns are great shots with the guns. I mean, most people they buy a gun, they stick it in the dresser drawer, and that's the end of it. So you have to use a judicious eye when you're looking at training. And the best thing you can do is get training from a variety of sources, because if you're completely naive to training and you go to one instructor, that instructor is going to seem like a world-class genius to you because you just don't have any context in which to evaluate them. It's not until you've been to a few different instructors that you really get that broader context. And by the way, that's one of the great things about these tactical conference by Tom and Lynn Givens and the Guardian conference put up by concealedcarry.com is you can't get a lot of depth of instruction from any particular instructor over the course of those 2 or 3 days because there's so much going on. In fact, most of them have parallel tracks, so you can't even take every class offered during the conference because things are happening simultaneously. But you can get an exposure to such a variety of instructors and perspective and skill sets that it really puts you in a much better informed position to evaluate training going forward. So certainly agree, Will. Take a look again at the super chats. Yeah, for folks coming in late and man, don't you folks have anything better to do on a Friday night than listen to a lawyer talk about self-defense law? Just kidding. Me either. That's why I'm here broadcasting. This might be a good time actually to remind everyone again, because I see a whole bunch of new people have come in, that tomorrow, less than 24 hours from now, at 2 p.m. Eastern Time, we're hosting one of our 100% free law of self-defense hard to convict webinars. This is a just under 2-hour, absolutely free webinar in which we bust some common self-defense law myths, the kind of things that are commonly believed about self-defense law, but which, if followed, simply put you on a fast track to a prison cell, often for 10, 20 years more in prison. So you don't want to do those things. We bust those myths, and we show a path for transforming yourself from being easy to convict because you only think you know where the legal boundaries are for defending yourself and your family, to being hard to convict, because you can be extremely hard to convict if you knew where the actual boundaries of self-defense law were. So we show you that path to transformation to hard to convict in this webinar, the Law of Self-Defense Hard to Convict webinar. They're free. They're 100% free, but they are each limited to 100 seats. I'm not even sure we have seats left for tomorrow. You'll have to go to that website and check, lawofselfdefense.com/hard to convict. If the date's still listed, that means we still have at least one seat available, so you can grab that. If not, there are later dates that should also be listed, unless they're also full. I should have checked, I guess, before I came on tonight, but easy enough for you to check out. Go to lawofselfdefense.com/hard to convict for that. Yeah, today's show, Law of Self-Defense show, is sponsored by Law of Self-Defense. So that's our sponsorship promo there. Okay, let's see. Quick look again at the super chat, see if anything else has come in. All right. Back to our Q&A. Our platinum member Q&A. William L. Yeah, okay. So unfortunately, I can't answer William's question, but it's a good opportunity to clarify this point, as I'm obliged to do from time to time. Um, William says, I'm a resident of Virginia and I have a concealed carry permit for Virginia. If I travel to New Jersey with my firearm, can a federal air marshal arrest me in the state? I do not have a permit for a firearm in New Jersey. So the first thing I'll say, William, is I do use of force law. I don't do gun law. Those are two completely different things. So use of force law is covers the legal boundaries of when you are permitted or not to use force in defense of yourself, in defense of another person, in defense of property. Really, I don't particularly care what tool you use for self-defense purposes or defense of others or defense of property. I care a lot about the degree of force you use because that has self-defense law implications. But it doesn't really, if you're privileged to use deadly force in self-defense, for example, the law doesn't really care if you're using a gun or a knife or a bat or a piano dropped from a great height. If you're privileged to use deadly force in self-defense, you're privileged to use deadly force in self-defense, whatever the particular form that deadly force takes. So it's use of force law is not particularly firearm specific. Gun law is completely different than use of force law. Gun law has to do with things like the question you ask. If I have a Virginia permit and I carry into New Jersey, what kind of trouble am I going to get into? It's things like, do I need a concealed carry permit to do this? Is it valid here? What kind of guns can I have? What kind of ammo capacity can I have? Does my state allow for suppressors? Blah, 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 blah. I don't do gun law. I don't do any of that. I know the exact amount of gun law I need to know as a gun owner who carries and travels with guns. I can tell you one thing with that disclaimer that I don't do gun law. I would never bring a firearm into New Jersey without ensuring I had the appropriate permits to possess that gun in New Jersey, which I do not. So I would never bring a gun into New Jersey. Whatever permit you have in Virginia is going to be absolutely worthless in New Jersey. Now, of course, there is federal law that purports to privilege you to transport a gun through New Jersey. I believe the criteria, and again, I don't do gun law, but I believe the criteria is the gun has to be locked in a box, inaccessible by the driver or other passengers in the vehicle. So in the trunk, for example, which could be tricky if you're in an SUV without a trunk. The ammo has to be separate from the gun, things along those lines. But I can tell you for a fact, New Jersey state troopers do arrest people that they find on a traffic stop on I-95 or the New Jersey Turnpike with guns in that condition. And basically they say, well, go tell it to the federal judge. We're charging you. And if you want these charges dismissed under federal court, go to federal court. Tough luck. You're under arrest. So I just wouldn't do it. Any of those super hard gun control states, just find out where you're actually lawful. Concealedcarry.com has a great book on this. Well, I have a copy around here somewhere, but it's not within arm's reach because I just reorganized my desk with all the new monitors and stuff. But they have I believe it's called Gun Laws in the 50 States or something like that. So inform yourself about where you're legal, but I can almost assure you, you're not legal to have a gun in New Jersey. And the punishments can be quite severe. So felony convictions for sure. So my advice is just don't do it. All right, next question. The Dante Wright shooting trial. On the body cam video after the shooting, it seemed like the DA, the prosecutor, was asking about Ms. Potter's statement, "I'm going to prison." You'll remember this is the taser shooting. So the officer, Kim Potter, had been part of a traffic stop on Dante Wright. He fought arrest, jumped back into his car, tried to drive away. She believed she was pulling her taser, shouted, "Taser, taser, taser," pressed the trigger. And in fact, she had pulled her Glock pistol and put a 9mm round into his Dante Wright's chest and killed him. For which she was tried for essentially a reckless murder charge. Found guilty, could have been subject to as much as 20 years or more in prison. was sentenced ultimately by Judge Chu to 14 months in prison. Now, sounds like a great deal, except the problem was she was convicted on a crime based on recklessness, and the jury was misinstructed on what's required for recklessness. So her conviction was actually a complete travesty of justice. She should have had no prison time. She should have been acquitted. But in any case, one thing that didn't help her much was after she unintentionally shot Dante Wright, he raced off in the car for a couple blocks. He was mortally wounded, so he would crash a couple blocks away, smash into another car after losing consciousness from the gunshot wound. And Miss Potter realized she'd shot someone she had intended to tase, and she had lamented on the scene, distraught, "I'm going to prison." So was that, how was that? Let's see, the prosecutor, and this was all caught on the other officer's body camera video. And the other officers basically told her, "No, you're not. No, you're not. You're not going to go to prison." So the question is, does Ms. Potter's statement, "I'm going to prison," count as an excited utterance and therefore offered as her admission of guilt? And if so, is there a defense to that? Well, it is an excited utterance. It occurred under the excitement of the event, and therefore it would be an exception to any kind of hearsay objection. Also, it's a statement against interest. So that's another exception under hearsay. So the hearsay, the doctrine of hearsay, excludes out-of-court statements introduced for the truth of the statement unless they meet a certain exception. So the hearsay doctrine itself is really easy. So if somebody said something outside of the courtroom, you can't have a second person repeat their statement inside the courtroom. If you want that statement repeated, you have to get the person who said it in the first place. If some other person repeats their statement, that's hearsay. That's inadmissible evidence. So straightforward enough, right? Unless it meets an exception. So hearsay is simple. The exceptions get really complicated. There are, I don't know, maybe 50 exceptions to the hearsay rule. One of them is excited utterance. Another is statements against interest by the defendant. Both of those would certainly apply here. So there was never any doubt the statement was going to be admissible in evidence. To the extent Scott here, who asked this question, is characterizing it as an admission of guilt, that's certainly what the prosecutor wanted the jury to infer. That's the defense ought to, and I don't know if they did or not, I don't recall now, but they ought to have offered the jury a different interpretation of that statement, which is not that I'm going to prison because I'm guilty of a crime, but I'm going to prison because this horrible thing happened in an environment in which police officers who shoot young black men are persecuted by the criminal justice system and unfairly convicted. That's almost certainly what she actually meant by that statement. Not that she's going to prison because she deserved it, but because she's going to prison because that's what happens to officers who shoot young black men under questionable circumstances in today's environment. Also, her saying she's going to prison is not a conclusion of law. It's not up to her to decide. And it wasn't simply a statement of underlying fact. So it wasn't like she said, "Oh, I'm glad I murdered that guy." That might be different, right? Here she's talking about the consequence of the action, not the lawfulness or not of the action. So the defense is to offer, to her making that statement, the defense is to offer the jury a different inference that they can make, other than that she's somehow handing them a conclusion of guilt. Let's see. Next question from, is this the same David? No. David L. from Pennsylvania. He asks, can you use deadly force to protect your animal dog from attack? Let's see. Well, this is like an 800-word question. He adds a lot of really complicated detail in the hypothetical, referencing things like PA fish and game laws. And sorry, I can only answer these questions in a more general format. So can you use deadly force to protect your animal from attack? Well, we need to know more about this hypothetical. Are you intending to use deadly force against a person who's attacking your animal or against an animal that's attacking your animal, your dog, for example, because it makes a difference. The threshold for using force against some other animal is lower than the legal threshold required for using force against a human being, as you might expect. If you're using force against another human being, you'll have to justify it um, as a lawful use of force in self-defense, and you'll have to show those 5 elements of self-defense and hope the prosecution can't disprove any one of them beyond a reasonable doubt. So if you're using force against another human being because they're threatening your animal, keep in mind your animal, your dog, is not a human being. So you're not defending another person. You're not defending human life. You're defending a pet. And I know pet owners don't like to hear this because they feel like their pets are as much a member of the family as the humans in the family, maybe more than the humans in the family, depending on your humans, I guess. But the law considers your pet simply personal property. And in 49 states, you're not privileged to use any defensive deadly force against another person in defense of mere personal property at all. Now, Texas is the one exception. Texas does have a provision for the use of deadly force in the context of defense of personal property, which would include a pet. You can find that at Texas Penal Code 9.42 or at lawofselfdefense.com/942. When you look at that, you'll see there's a lot of hoops that have to be jumped through for that statute, including things like certain offenses have to have taken place at nighttime. You have to meet all the conditions first for using non-deadly force in defense of personal property. And if you fail any of those hoops or conditions, you don't qualify under statute Penal Code 9.42, in which case you wouldn't have a legal justification for your use of force. So I would caution against using deadly force against a person in defense of your pet. Now, if you're standing beside your pet, you might make a reasonable inference that someone attacking your pet is about to attack you next. But in that case, we're not talking about a defensive pet scenario. We're talking about a defense of yourself scenario, which is a straight up self-defense analysis. So that's if you're contemplating defending your pet from a attack by another human and thinking about using force against another human. That you have to justify on straightforward self-defense grounds, which might be difficult to do if the reason you're using force against the human is defense of property, which is what your pet is. Now, you can always use non-deadly force in defense of your property. So you could use non-deadly force in defense of your pet. But once you escalate to deadly force, it needs to be a defense of persons, not a defense of pet scenario when you're using deadly force against another person. What about if your animal is being attacked not by another person, but by another animal? Well, that's a different scenario because now you don't have to justify the use of force against another human. You're only trying to justify the use of force against another animal. And the threshold is much lower. And normally the legal defense there would not be self-defense or even defense of property, really, because you're not using force against a human. So you wouldn't be applying those legal defenses. You'd be applying probably what's more commonly called as the necessity defense or the doctrine of lesser harms or the doctrine of lesser evils. Different states call it different things, but every state has some variation of this defense. And basically the idea behind the defense is, yeah, sure, I may have committed some modest wrong when I did X, when I shot that dog, for example, but I did that to prevent some greater harm, the death of my own dog, or frankly, an attack on yourself, right? If you were attacked by a dog. So if you shoot another dog, you don't have to justify that as you would if you shot another person, but you would need to justify the use of force because you can't just walk around shooting dogs, right? That would be inappropriate. So the necessity defense is what you would apply. The great thing I would caution here, however, is it's extremely common for people who discharge a firearm towards another animal or in a warning shot in the face of a threat of another animal in defense of their own pet. It's very common in those scenarios, especially if it's in a populated area, for law enforcement to show up and arrest you for reckless endangerment of the people in the community where you fired that round, because bullets don't actually miss anything, folks, right? A bullet continues moving until it hits something. So if you discharge a round under circumstances that the police find not credible or questionable, don't be surprised to find yourself charged with felony reckless endangerment because that round you fired endangered anybody who might have been in the vicinity. And that's a pretty serious felony charge. So I would be extremely hesitant to be discharging rounds. Now, if you're at sea and your dog's swimming and is attacked, a shark is approaching and there's no threat to persons, well, I guess you can unload on the shark. If you're deep in the woods and it's unlikely there's another human being around, well, then maybe you don't have to worry about the reckless endangerment issue. But if you're in your HOA, I would be for sure worried about it. By the way, just like dealing with people, when dealing with potentially dangerous animals, it's smart to be prepared not only with deadly defensive force, but also with non-deadly defensive force, something like OC spray. OC spray, especially if you get the stream, might be tricky to hit a charging dog with, for example. But they also sell it in more of a cloud or mist variety, and dogs have a lot of mucous membranes on the front of their face. So there you go on that. Hope that clarifies things a bit, David. What do we got for time? Well, we're just over an hour in. So let me take another look at the super chats. Here's CRJR. He's contributed in the past. Thanks again for this new super chat contribution, CRJR. I appreciate it. Not a self-defense question. Have you ever seen Sasquatch out riding? Not the real Sasquatch. I've ridden all over the U.S. and in Canada and Europe, and I've certainly seen people who could be mistaken for Sasquatch. Some of them riding motorcycles, but I've never seen the actual genuine Sasquatch. All right, folks. So I'm going to remind everybody just one last time, very briefly, about tomorrow's Law of Self-Defense Hard to Convict webinar. It's at 2 p.m. Eastern Time tomorrow. You can sign up at lawofselfdefense.com/hard to convict. Doesn't cost a penny, folks. If there's a seat available, you can grab it at lawofselfdefense.com/hard to convict. If you don't see tomorrow's date on that page, it's because we filled up every seat. It's only 100 seats per webinar, but there ought to be later dates also listed that you can pick from. So pick a date that's convenient to you. I believe they're all at 2 p.m. Eastern Time, noon my time. Myth busting, and we show you a path to transform from being easy to convict, which is the probable state of most of you watching this, to being really, really hard to convict if you're ever compelled to use force in defense of yourself or your family. Again, that's at lawofselfdefense.com/hard to convict. And with that, folks, I will get ready to wrap this up with our little extra. Except I will remind you all once again, as I always do. First, I'm attorney Andrew Branca for Law of Self-Defense. And second, if you carry a gun, own a gun, so you're hard to kill. That's why I have a gun. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the actual law of self-defense, so you're hard to convict if you're compelled to defend yourself, your family, or your property. All right, folks, until tomorrow, hopefully a bunch of you will join me for the Law of Self-Defense Hard to Convict webinar at 2 p.m. Eastern Time tomorrow. I look forward to seeing you there. And until then, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.